Defendants and another on the building site.
Yes, Mr. Stratton.
Good morning, my lords. My name is Harry Stratton and I represent Mr. and Mrs. Evans, the homeowners and the appellants. I'm assisting them pro bono through advocate. My learned friend, Mr. Forsyth, represents the Building Society. My lords, Mr. and Mrs. Evans, as you know, only received pro bono assistance on Monday afternoon. I'm playing a fair bit of catch-up on proceedings that have been going on for some years and 1,000 pages of bundles. That includes more than 100 pages the Building Society added out of hours yesterday, and then 82 pages of authorities at 7:30 this morning. At the outset, I just want to make sure we're all looking at the same documents together.
Right.
I apologise, that might take a little bit of time, but I think it will save us time.
Well, perhaps before we even get to that, can we ask what's in issue today?
Yes.
So we know that I think it's agreed this appeal is going to be allowed.
Yes, my lord.
My lord, yes.
On the simple point that the judge was wrong for the reasons. Well, he was wrong. It seemed to us there were two. The next question is whether we should constitute ourselves as the High Court and deal with the oral renewal. If we're able to do that, if the documents are there in the bundles for us to do that. And then lastly, there's your skeleton makes a request for a stay or an injunction. We're not entirely clear there's any application for that before us, so we need to be persuaded of that. Is there anything else other than those 3 points, one of which is agreed, that is before us today?
The last point, my lord, is if you were minded to defer the oral reconsideration, there's a discussion about whether that should be before the High Court in London or in Cardiff.
Right. Okay. But there's a hearing in Cardiff taking place later in August, September, which is supposed to be heard together with. Is that right?
It's not listed yet, my lord.
But is that in Cardiff?
The proposal was that would be in Cardiff, but it hasn't been actually listed yet.
Right, but that's not the listing of that, or the destination, London or Cardiff, of that application. Is that before us as well? Are you asking us to direct that application be heard in London rather than Cardiff?
I think I am, my lord.
Right. Okay. Well, we'll get to that when we get to it. Yes. So the bundles.
So the bundles, and I apologise for taking this slowly. First, I've got a core bundle, which Mr. Forsyth calls Bundle A. That's of 44 pages. Second, I've got a supplementary bundle, which Mr. Forsyth calls Bundle B. That's 339 pages. Third, I've got an application bundle, which Mr. Forsyth calls Bundle C. That's 82 pages. Fourth,
just a moment. Is that one headed N244 application appeal bundle?
yes, Judge.
Yes. Yeah.
Apologies, yes, my lord.
Yes.
Fourthly, I've got an ancillary bundle, which Mr. Forsyth calls Bundle D, and that is 126 pages. And then fifthly, I've got the Respondent's bundle of additional documents, which Mr. Forsyth calls Bundle E. There's two versions of it, but the correct one is 351 pages. And that's sent out of hours last night.
I don't know that.
I don't know. No. So, my lords, I believe that was handed up this morning.
Right.
The page number will now be slightly higher because I think one of your clerks has helpfully added in 2 additional documents at the back of that, which weren't initially enclosed. My learned friend has a copy of them. So those 2 at the back won't be.
How many pages does this run to now?
Apologies, my lord.
351 that are paginated, my lord. And then there are these 2 additional documents which should take it up to, I think, an extra 35 pages or so.
I don't have those 2 additional documents.
So those are the 2 I handed up. So the 2
I see.
separate ones.
I see.
I've got a bundle which is 351 pages. I've got something called Authorities, which I've got, this is the earlier bundle, I think. That's an irrelevant one. So, 351 pages, where's the extra 35?
I understand they've been added at the back.
Wasn't mine.
They were just loose in the back of mine, and one clip starts in the letter of the 17th of November 2025, and then there is another clip that starts with the order of Michael Green J of the 11th of December.
Okay,
My lord, yes, that's correct. So they are the grounds of appeal that were advanced by the appellants against His Honour Judge Kember's order dated the 23rd of October 2025, and then the order of Mr Justice Michael Green refusing permission to appeal in that application. And the reason that we've included it is that it may have a bearing on what my learned friend is going to address you on concerning their CPR 52.30 application.
That he put in the back of the authorities bundle.
Right.
Do you have them?
So, wait a minute, I'm getting confused. So the... Oh, I see. Yeah. Same things happen with
Yeah.
mine.
Right, I think we've all found those.
Great, thank you.
Thank you, my lord. There's 3 other key documents which I hope that the court has seen. The first one is a witness statement from Mark Hughes of the Building Society.
Yep.
That was filed late yesterday afternoon. The second one is Mr Forsyth's supplementary skeleton argument filed on Monday afternoon.
Yep.
And I've also got our final representations filed on Tuesday.
Yes.
And with them, my lords, there was an application notice, the draft order, and that was the application notice for the injunction.
So where's that?
That was filed with the representations, my lord.
So it's not found its way into any of the bundles?
I know.
My lord, I think it has. That's part of the reason why we updated the bundle yesterday, the new bundlee. So, my learned friend's application.
Mr Forsyth is quite right. It is at page 250 of the updated bundle.
Right.
So indeed, and the witness statement filed by Mr Mark Hughes of the Building Society is also in that same bundle at page 276.
I see, yeah, thank you.
So, my lords, thank you for bearing with me during that slightly laborious exercise. We're on the same page with the documents. Might I proceed with my submissions?
Yes.
Can I just check, is that the application in our bundle seems to be a draft application in the sense that it doesn't bear a stamp?
It doesn't have a seal, my lord. We now have a sealed version.
So that has happened?
Yes, yes.
Right.
Apologies, I should say there is a sealed version. We've sent it via email to the respondent, asking them to accept that as service. We haven't had a reply saying they will accept it, but we anticipate that will be forthcoming, and I don't imagine any objections taken to that.
Right.
My lords, Mr and Mrs Evans are acting as litigants in person in these proceedings, in which the Building Society is trying to sell their home under a deed of charge. I want to be clear at the outset, their status as litigants in person is not by choice. They can't afford private representation because their only real source of income is universal credit. They're not eligible for legal aid for this case, and on Monday afternoon they obtained pro bono assistance from Advocate for the first time. What I propose to do in these submissions, in light of what you've told me, my lord, is this. I'm going to give you the points in some detail, but I'll give you the headlines now. First, I'll set out the background about the deed of charge and what Mr and Mrs Evans say is wrong with it. In summary, there's fresh evidence that the deed of charge is not valid because it wasn't properly witnessed and because it was materially altered without their consent. Second, I'll give you a very abbreviated version of the complicated procedural history. Third, I'll deal with what can be decided today. And the headline, as my lord has pointed out, is that the appeal should be allowed on the narrow point that Mr and Mrs Evans were wrongly denied oral reconsideration. And the Building Society doesn't oppose that order. Fourth, I'll make submissions about what should happen next. The headline is that we are asking this court to defer the oral reconsideration to the High Court hearing in August or September 2026. That was actually the course the Building Society originally urged, and the Building Society remains open to that as an alternative course of action. My Lords, I'm not being modest when I say I'm not in a position to deal with the oral reconsideration argument today. I'm not in a position to make submissions in which someone's family home is at stake. I've worked on very little else since Monday afternoon. I'm still getting on top of these quite complicated proceedings. Fifthly, I'll make submissions about what should happen in the meantime between now and that proposed High Court hearing. In summary, Mr. and Mrs. Evans are asking for an injunction preventing the sale of their home in the meantime. That's on the basis that it's only a short delay, but if the home is sold in the meantime, their appeal is rendered pointless. We also have real concerns about the way in which the home is being sold. And those concerns only came to light in light of the Building Society's new bundle served out of hours yesterday. It seems that having received one cash offer for £900,000, the Building Society only advertised the property on one website for 14 days thereafter, insisting that potential offerors beat that offer and provide evidence of funds in those 14 days. And we say that's a breach of their duty to get the best price reasonably obtainable. In fact, we say the house is worth £1.2 million, some £300,000 more than they're selling it for. And that's actually the same price that these same agents listed it for and advised that it would be listed for when they were previously working for Mr. and Mrs. Evans. And that difference, my lords, is enough to wipe out Mr. and Mrs. Evans' debt to the Building Society. So those are the 5 headlines. With the court's permission, I'll turn to the factual background.
What is the level of debt at the moment?
The level of debt, as the Building Society states it, I think is slightly over £1 million. We haven't had sight of their calculations and the interest calculations and the cost indemnity, but if we take their figure at face value, if it is £1 million,
that includes interest and costs.
Yes, my lord, as I understand it.
So, my lord, the figure outstanding on the mortgage account is at least 1.037 million. That doesn't include legal costs since the 8th of May this year, which are estimated to be a further £60,000. And drawing this all together, assuming that this proposed sale to a cash buyer did take place, say in September this year, the Building Society estimates that the appellants will probably owe them more than £200,000 on an unsecured basis once the costs of marketing are also taken into account. So that's the potential shortfall that the Building Society is directed.
Sorry, if the property is sold at the current...
At the current price.
Right, which is what? What's the current price?
900,000.
Yeah.
With marketing agents having advised them to put it on the market at 880, there is now a cash buyer for £20,000 above that.
My lord, just to make one last point about the maths, obviously if we do manage to sell it for £300,000 more, that leaves Mr. and Mrs. Evans debt-free to the Building Society.
There are other charges on this property, aren't there?
Yes, my lord.
Yeah. What's the amount of those?
I don't have that information. I'm sorry, my lord. In relation to the factual background, the underlying dispute concerns the family home at 71 Mumbles Road. The home was financed with the aid of a loan from the Building Society, and the same solicitors at DJM acted for Mr. and Mrs. Evans and the Building Society in putting together that transaction. As part of the transaction, DJM would arrange a charge over the home in favour of the Building Society. My lords, I'm not proposing to take you to that many documents, but let me show you part of the charge. We're looking at Bundle D, page 30.
I don't have letters, so remind me which one it is.
It's the ancillary bundle, my lord.
Yep. Sorry, page?
Page 30. If you're looking at the PDF, apologies, it's paginated page 30, page 31 of the PDF. And you'll know you have the right one if it begins mortgagor were a company.
Sorry, I'm lost. Which bundle are we talking about? What's the ancillary bundle look like?
It begins ancillary bundle index, my lord. If it's helpful, I can give you a hard copy of bundle D.
I prefer to work on this, but it's on 126 pages.
126 pages, yes, my lord.
And page 30, you say?
Yes, page 30.
Sorry, could I have a hard copy, please?
Of course, my lord.
Thank you very much.
Thank you, my lord. Would my lords also like a hard copy?
No, I'm already there.
No, thanks.
Thank you, my lord, and thank you for bearing with me. Now, this is the signature page of the charge. It purports to be executed as a deed, as a registrable charge has to be. And I'm telling you things you already know, my lords, but that means it was required to be signed by Mr. and Mrs. Evans in the physical presence of a witness who attested to it. And that's section 13AI of the Law of Property Miscellaneous Provisions Act, 1989. And because it's a deed, that means it was subject to the rules in Piggott's case about post-execution alteration. I'll come back to those a little later. Now, if we look at the bottom of the signature page, we can see the deed is apparently signed in quite an unusual way because there's actually 5 signatures there. The top 2 appear to be the same. You can just about make out H. Kelly. And take it from me, Helen Kelly was the DJM solicitor. Then there's 2 signatures to the right of the parentheses that seem to have been struck through. And then at the very bottom of the page, there's another signature, the witness signature, which purports to be from V. Henshaw of 103 Newton Road. Now, Mr. and Mrs. Evans don't believe they ever attended the sort of signing meeting at which a charge would be signed and witnessed. And they don't believe they ever met the witness to the charge, Vicky Henshaw of 103 Newton Road. They were working with DJM by email and post. When they signed documents, DJM posted or emailed them to them, and then they signed them and returned them in the same way. But only after the appeal was filed did they discover 2 very unusual features of the charge. Number 1, on 13 April 2026, Mr. and Mrs. Evans finally managed to reach Miss Henshaw. Now, because I was only instructed on Monday, my lords, I haven't got a witness statement from her yet, but I do have a witness statement from Mr. and Mrs. Evans about the call they had with her. That's at page 43 of this bundle that we've been looking at. Here is what happened in that conversation. We're at page 44, paragraph 10. During that conversation, Ms. Henshaw asked words to the effect, "Do I know you?" To which the first claimant replied, "No." Stated that she has worked at Douglas Jones Mercer in 2018. Stated that she was a receptionist. Stated that she was not involved with official documents of the firm. Stated that DJM had not been in touch with her. Stated that she did not sign the charge or any charge dated 7 December 2018. And if we look over the page at letter G, stated that she did not witness our signatures on any official documents or any charge dated 7 December 2018. And in fact, my lords, there's another oddity about the attestation in the deed. The address given for Ms. Henshaw is 103 Newton Road. But Ms. Henshaw actually lives at 42 Fjord Taliesin, and I apologise for butchering that. So if Ms. Henshaw did witness the deed, apparently she's mistaken about her own address on this document. Now, I want to be clear about what I'm suggesting, my lords. I'm suggesting there was no signing meeting. If this deed was signed, it was signed in the same way as the other documents and then sent by post. Then someone realised the attestation was missing and put in Ms. Henshaw's name as a witness. Now, I don't know for sure if the person who did that fully appreciated what they were doing, but if I'm right that the deed was executed in that way, it can't take effect as a deed at all. Now, I said there was a second unusual feature of the deed. Mr. and Mrs. Evans only discovered that on 26 May 2026, after the appeal was filed. And that was when, after more than a year of asking, DJM actually provided them with their conveyancing file, and in particular, some correspondence with the land registry that I'm going to show you. First, let me show you the first version of the deed. This is on page 23 of the same bundle, or page 24 of the PDF. Now, the critical difference is on the signature page. And you can see here, first of all, there's no H. Kelly. There's no statement of the name of the person who signed the deed, just two signatures to the right of the parentheses. And for what it's worth on this version, it's also a bit clearer that the first two signatures and Ms. Henshaw's attestation are in different pen. Now, after completion on 7 December 2018, this is the deed that was sent to the land registry, and the land registry rejected it. We're looking now at page 26 of the bundle.
Whose signatures are those, by the way? Page 23.
My lord, Mr. and Mrs. Evans don't remember signing the deed because there were lots of different documents, but I think the respondent's case is that they are Mr. and Mrs. Evans' signatures, and I think they do look a bit like Mr. and Mrs. Evans' signatures.
Right. So, okay, they don't remember it, but they don't say they're not the signatures.
No, my lord, they say they don't remember signing this document, but they don't actually say it's a forgery, for example.
No.
So here is what the land registry said at page 26 of the bundle, beginning with the big word requisition. Thank you for your application for registration affecting the above property. Unfortunately, we are unable to complete the application until you are able to deal with the following. We are unable to read the signatures of the persons who have signed the charge. Please note that under Rule 2063 and Schedule 9 of the Land Registration Rules 2003, the full names of the persons signing must always be set out in the execution clause, and the signatures must appear by or under each name. In this instance, the signatures of the persons who have signed the charge do not appear by any name stated in the execution clause, and we are not able to read or associate the signatories with any particular name. And so if we go back to page 30 of this bundle, we can see what DJM did to try and correct the problem. You can see in print under signed as a deed, someone inserts Paul Morgan Evans. And in fact, they do the same for Mrs. Evans in the other signature block over the page. Then they strike out the signatures to the right of the parentheses, and H. Kelly's signature is put next to those changes. And this is the document that is resubmitted to the land registry. Now, Mr. and Mrs. Evans say they never knew about that change, they never consented to that change. And my lord,
You say they strike out the signatures. Why do you say that?
it's just from comparing the two documents, my
But
lord.
the signatures had a sort of line going through them in the original version.
My lord, if you compare pages 23 and 30 of the bundle,
Yeah, that's what I'm doing.
especially the second one, I think there are additional lines, and I think there is an effort to strike it out.
Well, there seem to be lines through the, because what it looks as though if you look at the signature on 23, there's a signature, and then it looks as though someone has actually written the name underneath of the person signing, and then crossed that out for some reason on the original one. And then in the one on 30, the signature actually looks the same, but the name underneath has been scrubbed out. And then the name has been written in.
My lord, if you look at 30 and 31 next to each other, I think it might be slightly clearer. I think what happened in attempt 1 was Mr. and Mrs. Evans' signatures were put twice, once against each execution block. And you can see for that reason on 30 and 31.
Yeah, I can see on 31, I can see your point there,
Yes,
where
thank you.
it looks as though the signature itself has been scrubbed through. Yeah.
Thank you, my lord.
Sorry, so is this what you're saying? That on page 30, Mrs. Evans' signature is crossed out, but Mr. Evans is not. On page 31, the reverse has happened.
Yes, my lord.
Yeah.
So what I think has happened is originally both pages were signed by both people, and then they crossed out.
So they
one
just
each.
crossed out the irrelevant signature on each page.
Yes, my lord.
It added the identity of whose signature it was.
Yes, my lord.
Yeah.
Now, look, in relation to whether or not Mr. Evans and Mrs. Evans consented to that change, they say they never knew about the change, and they say they didn't consent to it. Having got to know Mr. Evans over the past 3 days, he is a person with pretty strong opinions about how things should be done. He's not the sort of person who lightly accepts a fudge or a fix, and he is the sort of person who demands an explanation about what each document means. He is the sort of person who would remember it being messed up.
But
complaining about it.
the solicitor was acting for your clients.
My lord, we say, apologies, the solicitor was acting for both the bank and my clients.
Yeah, but certainly acting for your clients.
Yes, my lord. The solicitor did this on the instructions of the bank. She did not have instructions from my clients.
Well, what had happened was that your clients had given instructions to give this charge. Your clients had signed the document. Leave aside the witnessing point at the moment. They'd signed the document. It didn't have a sufficiently clear identification of their name. The land registry pointed that out. So Miss Kelly then essentially wrote in their names, put her signature next to it and sent it back.
Yes, my lord.
But she was acting for your clients.
My lord, we say she didn't have authority to submit this document.
Well,
just
did she
on
need
instructions.
further authority? That your clients had given her authority to perfect a charge in favour of the bank.
We say she did need further authority, my lord, and that's in part a timing reason. Completion happened on the 7th of December 2018. She wrote a letter to my client saying completion has happened. Effectively, our engagement is at an end. She didn't have authority to submit another deed with a variation in January. And I appreciate, my lord, you can probably think of potentially some counterpoints to that argument. But the point I'll make if we do have oral reconsideration today is it's at least a reasonably arguable, it's at least a point with a real prospect of success to say that her authority came to an end when the engagement came to an end. She wasn't entitled to keep submitting documents after that, at least not without Mr. and Mrs. Evans' instructions. Now, I understand, my lords, my learned friend has another legal argument that there was consent, and that argument is based on a power of attorney in the deed of charge itself, in which Mr. and Mrs. Evans authorised the Building Society to act as their attorney. Suffice it to say, we don't agree, and there's a few different prongs to that legal argument, but I might come to that a little later, or in the course of oral reconsideration, rather than take up your time now. So that's the factual background. Let me now give you the critical procedural history. At the outset, my lords, let me say this. It's fair to say it is quite a complicated history. It's also fair to say, had Mr. and Mrs. Evans been legally assisted throughout, it probably would be a less complicated history. And going forward, we are going to try and streamline the outstanding procedures and narrow the issues, or at least put the documents into a more comprehensible form. But it's not fair to say that Mr. and Mrs. Evans have deliberately tried to hijack the court's processes. They're litigants in person, they don't fully understand these processes, but look, they do have fresh points about the validity of the charge, and those points have never been considered in any of the proceedings below, and they want that evidence heard and determined for the first time. And now that they have pro bono legal assistance, they don't intend to keep going around making applications. They intend to make the legally correct applications for that outcome to be achieved. Now, the really simple version of the procedural history is as follows. The Building Society has in hand a possession order for their home. I understand that is the possession order that they're going to use with the land registry to put a transfer through if the sale does go ahead. Permission to appeal that possession order was refused, but neither of the points I've outlined to you about the validity of the charge was raised at that stage because Mr. and Mrs. Evans didn't know about them, so they couldn't tell the judge about them. And that brings me to these proceedings. Mr. and Mrs. Evans issued new proceedings seeking to challenge the validity of the charge, and they applied for a stay of the possession order pending determination of that charge. And His Honour Judge Kemba KC refused that stay and made limited civil restraint orders against Mr. and Mrs. Evans.
So those aren't the proceedings relying on these points, are they?
No, my lord. They made other points about the validity of the charge. These points are entirely new.
Those are High Court proceedings, were they?
Apologies, my lord. I think they were county court proceedings.
They were, and the applications were simply for a stay of the possession orders that had been ordered in earlier proceedings, and also an order setting aside the order that Judge Kemba had made on the 23rd of October. Those were the two applications which were then the subject of the appeal proceedings, which was then the subject of Justice Ritchie's order, and that is what is before us, it seems to me.
That's quite right, my lord.
Not the whole of your client's grievances about how they come to be in the situation they're in at the moment.
Yes, that's right, my lord.
So even if there were oral reconsideration, it's that narrow point, that is to say, the order that His Honour Judge Kemba made on the 16th of December, which is before us, not all of these additional points that you now wish to raise, but which aren't in effect the subject matter of these proceedings, because they're not the subject matter of what was before His Honour Judge Kemba on the 16th of December.
Apologies, my lord. I was with you until the last part of the last sentence. Let me just make sure you have the appellant's position clear. The appellant's position is this is not an appeal challenging the possession order. The appellant's position is this is an appeal in relation to the stay order. But points about the validity of the charge do at least have some relevance to the stay order, because if the judge below had been convinced that there were good reasons to challenge the validity of the underlying charge, the judge below would have been more likely to grant the stay. And so to that extent, it is relevant.
Can I just understand this procedurally? I mean, I had picked up that the second set of proceedings which your clients brought were brought in the High Court. That's what I thought.
Apologies, my lord. In relation to the second set of proceedings.
So there's a possession action and a possession order is made, and there were various attempts to appeal that which failed. So the possession order stands. I had understood that in August 2025 there was a new action brought in the Chancery Division, which under Part H, and where various points were taken about the validity of the charge, but not these two new points.
Yes, my lord.
Is that right?
Yes, my lord.
And then the application that was made to Judge Kemba for a stay was made in the county court, is this right? But for a stay of the possession order based on the fact that these new High Court proceedings had been commenced.
Apologies, my lord. I think we're at cross purposes in talking about the second and third proceedings.
Okay.
I might just lay out how I understand it, and then Mr. Forsyth can correct me if I'm wrong, because he was there. There was the possession order.
Yeah.
Then an application for a stay was made to His Honour Judge Kemba, and that application for a stay was in part based on the fact that there were third proceedings before the High Court, and I think that is where the procedural situation sat at that stage. But Mr. Forsyth,
So where,
if I'm wrong.
you say there are 3 sets of proceedings? Do you?
In fact, there's a fourth set of proceedings as well, but those are the 3 on foot at that time.
It's quite clearly set out, and I don't know whether you agree it or not, but it's quite clearly set out in the Respondent's skeleton argument, which sets out as an overview, firstly, the Part A claim that was brought in relation to an attempt to stave off possession proceedings, then the possession claim, which was brought following the demand for the outstanding sums, then the third claim, which is the Part A claim in the High Court, which was the subject of a transfer to the County Court at Swansea, which then led to the proceedings before His Honour Judge Kemba, which is the subject of this appeal. In the County Court, dealing, as I said earlier, with 2 applications, one for a stay and the other relating to setting aside orders or otherwise frustrating the order that had been made by Judge Kemba on the 23rd of October.
Yes, my lord, that chronology is agreed. I'm sorry that if I didn't explain it as well as Mr. Forsyth has.
Yeah.
So look, at that stage, I might come to apologies. We were talking about the application for a stay, which was refused. The next step is permission to appeal that stay, which went before Mr. Justice Ritchie. Mr. Justice Ritchie refused permission on the papers. He didn't make an order preventing Mr. and Mrs. Evans.
One of the reasons he refused on the papers is that he didn't have a properly constituted bundle in the appeal, and he didn't have, as was required, and I haven't seen it anywhere disputed, it's normal practice, as required, a copy of the transcript of His Honour Judge Kemba's extempore judgment, which was the subject matter of the appeal. And that's still the case, isn't it?
Apologies, my lord. In relation to the appeal bundle, you have the appeal bundles, but you're right that the transcript is...
So your appeal, even if we get as far as an oral reconsideration, your appeal isn't properly constituted in any event.
Yes, my lord.
Forget all of the other things. Mr. Justice Ritchie's point that you haven't got a properly constituted appeal because the appeal bundle isn't complete is still the position.
It is right, my lord, that the appeal bundle is not complete, but we say that would not be a proper reason for apologies. We say that it would be wrong to refuse oral reconsideration on that basis, and that Mr. and Mrs. Evans, being litigants in person who made this procedural error, should be entitled to get the transcript and put that before you, put that before either you or the High Court when there is oral reconsideration of these points. And my lord, I appreciate that's something that we would have to ask for relief from.
Well, have you asked for the transcript?
Apologies,
Or
my
not
lord.
you personally, but have your clients asked for the transcript?
Can I have a moment to confirm with them, my lord? My lord, Mr. Evans believes he has applied for it. I don't know how rigorously he's chased for it, but we can try and chase for it. It might be that there's an issue with the fees, for example, in which case I will try and solve that problem.
Thank you.
Just turning back to Mr. Justice Ritchie's refusal of the permission for application. Mr. Justice Ritchie refuses permission. It doesn't prohibit Mr. and Mrs. Evans from requesting oral reconsideration in that order. And CPR 52.42 provides that where the appeal court, without a hearing, refuses permission to appeal, the person seeking permission may request the decision to be reconsidered at an oral hearing. Now, upon receiving that order, Mr. and Mrs. Evans did make a request by email. And Mr. Justice Ritchie refused to consider it. And the reason he gave was that this email application is not made in a proper notice of application, was not made with permission under the LOCROs, i.e. the limited civil restraint orders, and has no standing. My Lord, I didn't see in the list of reasons the statement that the appeal bundle wasn't properly constituted, but I take my Lord's point about that. So Mr. and Mrs. Evans applied to this court for permission to appeal that order, and Lord Justice Nuggie granted it, and that's how we find ourselves here today. Just before I leave the procedural history, there's two other sets of proceedings that I want to advert to. The first one is Mr. and Mrs. Evans have made a claim to set aside the possession order for fraud, which is pending in the High Court. And that's the the Building Society has applied to strike that out, and that's the Cardiff strikeout application referred to. And the Building Society think they can get that listed in August or September 2026. Secondly, and this is the draft application notice that my Lord was referring to earlier, Mr. and Mrs. Evans have given the Building Society notice that they intend to seek permission to make a CPR 5230 application for a second appeal against the possession order. And the reason I say notice of that, my Lord, is the civil restraint order requires them to send the application in drafts, to wait 7 days and then to apply for permission to make the application. We think it would obviously be sensible for those issues to be dealt with all at the same time, because the complaints are really all about the same possession order and really all about the validity of the charge. So that's the very short version of the procedural history.
So sorry, that is to seek to reopen the refusal of permission to appeal against the possession order, is it?
Yes, my Lord.
On what grounds?
The grounds, my Lord, are essentially similar to the oral reconsideration points, that the deed of charge was either not validly executed because it wasn't witnessed, or was rendered void by reason of the rule in Piggott's case. And I can show you, my Lord, the draft grounds of appeal if you'd like.
Just show us that quickly. Where is that?
Of course, my Lord. It's in Bundle E, and it's at page 263. Yes, 263. It's behind tab 16. So the draft grounds of appeal are begin on page 263. The grounds themselves are set out on 264. The grounds are ground 1, fresh evidence in relation to witnessing, and ground 2, fresh evidence in relation to alteration after execution. So, my Lords, that's the procedural history. What can be decided today is whether the appeal should be allowed on the narrow point that Mr. and Mrs. Evans were wrongly denied oral reconsideration, subject to my Lord Justice Bean's point in relation to the constitution of the appeal bundle, which is taken. The Building Society doesn't oppose the appeal. Its position, in fact, in both the skeleton arguments it filed, is that the appeal should be allowed under Practice Direction 52A, paragraph 6.4, i.e. by consent and without determining the merits, if the court is satisfied there are good and sufficient reasons for so doing. My Lords, if you are minded to allow it to consent, I won't waste your time taking you through the legal analysis behind the appeal. If you would like to hear it or like to consider its merits, I'm happy to do that now.
No, we don't need that.
Thank you, my Lord. fourth headline is what happens next if the appeal is allowed, whether by consent or by determining it on merits. At that stage, Mr. and Mrs. Evans will be entitled to oral reconsideration of their application for permission to appeal against the refusal. As I've said, they say that should not be done at today's hearing, and that was the course the Building Society originally agreed with. We say that course is appropriate for 3 reasons. If you're against me on that, I will do my honest best to set out the reasons for it. But as I say, our position is that we think it should be deferred to a High Court judge. The first reason is that we just aren't ready to argue for it today. Now, my lords, these are 2 very poor people losing their family home. It deserves the very best argument that I can give it. But they've only just obtained legal representation, and the reasons for that are not their fault. I'm not being modest about this, my lord. I've tried my best to get on top of these different bundles. I haven't worked on very much else since getting these bundles. But these are proceedings that go on for years. There's numerous different interrelated claims. There's 5 bundles. There's over 1,000 pages of material, and that includes 82 more pages that Mr. Forsyth sent me this morning of further authorities. It will also take me some time to get a witness statement from Ms. Henshaw about whether or not she executed the charge, and if necessary, try and find a handwriting expert who will do it pro bono for us. And if I can't find one, then we'll have to make do. Now, I appreciate the last thing that anyone wants is more delay, but it may be that when Mr. and Mrs. Evans are properly advised, the issues can be narrowed and we can put in a single bundle in the proper form rather than 5 bundles with some documents disputed. And ultimately, the oral reconsideration just becomes a very short part of that hearing, dealing with strikeout and dealing with, hopefully, 5230. The second reason that deferral would be appropriate is that it overlaps that the oral reconsideration point overlaps substantially with the claim to set aside the charge, set aside the possession order for fraud, and with the proposed 5230 application. Now, both of those matters have to be determined by a High Court judge, and likewise, although I acknowledge the Court of Appeal can constitute itself as the High Court, the oral reconsideration would normally be determined by a High Court judge. My lords, we say it wouldn't make much sense to try and do the 2 procedures separately when they're all turning on essentially the same points, albeit viewed through different lenses and different legal tests. And the third reason we ask that oral reconsideration be delayed, my lord, is that the delay is relatively limited. It's July the 16th now, and the Building Society say the hearing can be relisted in August or September 2026. If your lordships are with me on that point, I can explain why we ask for relisting in London rather than Cardiff. If your lordships are against me on that, I will try and do my honest best with the oral reconsideration now.
So can I just ask this? You've identified at least 3 different procedural routes to get to the same end, which is to set aside the possession order.
Yes, my lord.
The only one currently before us relates to I think an application for permission to appeal against an order refusing a stay of the existing possession order. But the possession has now been given. So hasn't that route simply become overtaken by events? You can't now stay the possession order which has been given effect to. So you're left with your 2 routes. An appeal against the original possession, that will also may be too late, or more substantively, the application to set aside the charge.
I don't agree with that last proposition, my lord, and here is why. We agree that the possession order can't be stayed in the sense that we can't stop the Building Society being in possession of the property. We also agree that the possession order can't be stayed in the sense that we can't get a mandatory order to reverse their possession of the property by appealing refusal for permission for the stay. But staying the possession order does serve some practical purpose, and the practical purpose is this. If the sale were to happen now, the document that would be critical to making the transfer go through with the land registry would be the possession order. That the Building Society can show the land registry and say, well, this is the basis on which we say we can now make the transfer. If the possession order has been stayed, the transfer won't go through with the land registry because the building society won't be entitled to rely on an order in force for their possession. They can say, well, at the moment we have possession, but we have possession based on this order that's been stayed in that respect. And that won't be enough.
Is that right? Does the land registry require a copy of a possession order when a mortgagee sells?
That's my understanding of how it works, my lord. I might not be right about that. It's been a long time since I thought about residential conveyancing in that way, but that's how I understand it works.
Why would it need that? I mean, the mortgagee would be selling, and the purchaser would be buying, obviously. Does it require a possession order?
My lord, if you think about the documents that go in the pack, obviously document number 1 is we are selling under this deed of charge. But the fact that a deed of charge was entered into doesn't mean it's actually been enforced yet. The document that enforces the deed of charge, that is the prelude to the sale, is the possession order. And so we say, if the possession, we say the thing worth fighting about is whether the possession order is stayed, not because we're trying to kick the bank out of possession and get ourselves back into possession. We're saying if they can't use that order like that, they can't.
But it's already
transfer
been
the
executed, as my lord said, so it's too late to stay it. It's happened.
It's too late to stay physical taking of possession. It's not too late to stay the order for other
But
purposes.
ordinarily, the purpose of the stay would be to hold the ring and leave the party, the homeowner, in possession. But that ship has now long since sailed, hasn't it?
Yes, that's right.
And so all of your complaints about, well, we might be able to, it might be being sold at an undervalue, or it might be not being sold in the correct way, are all matters which will ultimately, when they play out in any damages claim or claim in relation to the account, to be made after the sale has taken place. The fundamental reason why one might grant a stay of possession order is completely evaporated in this case.
My lord, we agree that is the most common reason why people seek a stay of the possession order. I'd like to stay in my home, I don't want the bank to kick me out of it. But we say this is another reason why the stay of the possession order might be granted, to prevent the transfer of the property's title, as opposed to prevent someone from being kicked out of it. And if we were coming before you to say, well, what we want is repossession of the home by staying this possession order, you'd be absolutely right, the ship would have sailed, but we're not too late for that purpose because the transfer hasn't gone through yet.
Well, that then gives rise to the question of what weight can be attached to that purpose of you seeking a stay in circumstances where you're not trying to preserve the status quo, you're not trying to preserve your client's home because wherever they live now, they're not living there. So it's the question then of what weight one might attach to that consideration in assessing whether or not a stay ought to be granted.
My lord, I acknowledge we're not preserving a status quo in which my clients are in possession of the home, but we are preserving a status quo in the sense that we're preserving the status quo that the bank is in possession but title is with
Well,
my clients.
the property's not been sold, your clients are still racking up interest, the costs are still being racked up. That's the status quo that's being preserved, isn't it?
Yes, my lord, and I can fully see why, my lord, if you or I were in this position, we might say, well, the family home's not as important to me and I just want to minimise my cost liability. But for my clients, it is their family home and this is the position they've instructed me to put. I can make submissions in
But they're no
relation-
longer in possession.
Yes, my lord.
Can I just go back to that point? So you logically, the mortgagee's power of sale derives either from the power of sale in the mortgage deed, which we don't seem to have, but there must be one there, and or the statutory power of sale,
Yes, my lord.
neither of which depend upon possession. The reason you get possession is so you can give vacant possession to any purchaser. I'm just thinking through this in steps. Well, they have that. You can't stay that aspect because you can't, as you said, quite frankly accept. You can't reverse the possession which has been given. So I'm just wondering whether it is right that a necessary step in the sale would be the order of possession.
My lord, we say that it is at least an argument with real prospect of success for consideration, an oral reconsideration stage, that staying the possession order in the way that I've proposed to you can be something that prevents the transfer going through, i.e. that it's not just the fact of vacant possession, but also a legal basis for vacant possession that is required by the land registry, or more practically, required by any purchaser in order for the sale to go through.
So what you're actually seeking from us is some sort of order which prevents the bank from selling. It's not an order preventing the bank going into possession.
Yes.
And that's an injunction in substance, because what you're trying to do is interfere with any rights that the bank has to sell and to give effect to the sale. So the reality is that this isn't about a stay, it's about an injunction, isn't it?
My lord, I acknowledge the injunction legal lens is one obvious way of looking at it. We say you can look at it through the lens of stay, as I've outlined, but my lord, if you want to hear, apologies, if the court would like to hear the arguments about the injunction, at least in the meantime, between now and the proposed hearing in August or September, I can just make those arguments about the injunction now.
Well, I'm just trying to work out what's really being talked about here. We can come on to whether we look at those arguments in a minute, but having explored this a bit, it seems that you're accepting that possession has taken place. You're accepting that that cannot be undone because it's happened. The bank has such rights as the building society has such rights as it has to sell, whether under the charge or under statute. What your argument that there should be a stay in some sense of the possession order amounts to saying, and this isn't pejorative, that you want to put an obstacle in the way of the building society transferring the property to a purchaser. And that seems to me to be in substance an application for an injunction. Is that a fair summary of what you're really seeking here?
Yes, my lord, that is a fair summary. But we say that application, which one might most naturally think of as being an application for an injunction, and it is indeed the application for an injunction that I want to make in a moment, can also be viewed through the legal lens of an application for a stay of the possession order. And I acknowledge, my lord, you don't say an obstacle in a pejorative way, but if a person's family home is being sold and they don't want it sold and they have a legal right to make applications to put in obstacles, an obstacle isn't pejorative. That is what we're trying to do. My lord, in light of what you said about the substance of the injunction, would you be willing to hear, at least of NASA, the arguments about the injunction?
Yes.
Thank you, my lords. Apologies. Before I move on from the oral reconsideration point.
So you said to Benayesi, you do have an application which has now been issued. Is an objection taken to this being dealt with?
My lord, no. We received an email from the court yesterday afternoon saying that whilst that application hadn't been formally listed, the court would consider the extent to which the points raised within it could be advanced. So we are prepared to deal with that application if you are.
That's very helpful.
Thank you very much, my lords. Apologies, but before I go to that, my understanding is your lordships haven't reached a conclusion about whether or not you want to hear the oral reconsideration points at this stage. If you do reach that conclusion, I'll come back to the oral reconsideration points. If you decide not to hear it, I have some arguments about where it should be listed, but it sounds like the injunction and the meat of it is where the court would like to go at this stage. Have I fairly summarised that situation?
That's fair, I think.
Thank you, my lords. Mr. and Mrs. Evans are asking for an injunction preventing the sale of their family home pending the determination of those matters in August or September. And we say that application should be granted for 3 reasons. The first is that they have not just an arguable case, but potentially quite a strong case that the home should not ultimately be sold. And we say that for 2 reasons. The first reason is the compelling new evidence that the deed of charge is not valid. And if Mr. and Mrs. Evans are right about that, that means the building society is not entitled to sell their home at all. And that's a point that's never been determined by any court. The second reason is that there is strong evidence that the property is being sold in breach of the building society's duties. And I take my Lord Justice's point that if there is a breach of those duties, it's a breach that can give rise to a remedy in damages, but it's also a breach that can give rise to a remedy in an injunction. And I'll come to why that's the appropriate remedy in a moment. But just in relation to the breach of the mortgagee's duties, my lord, as you're aware from Cuckmere Brick and Mutual Finance, a mortgagee in exercising the power of sale owes a duty to take reasonable precautions to obtain the true market value of the mortgage property. Now, last night, the Building Society served us with a witness statement of one of its employees, Mr. Mark Hughes. That sets out the sales process, and it reveals 2 striking features of that sales process. My lords, we're in Bundle E, page 276, which is behind tab 18. And then within this witness statement, we're looking at page 278, paragraph 15. The first striking feature is that the home is being sold to a cash buyer for £900,000. And that is 25% discount on what the same agents advised and marketed it for previously when they were acting for Mr. and Mr. Evans. Mr. and Mrs. Evans, which was £1.2 million. Now, this has all the hallmarks of the Building Society wanting a quick cash sale and a discount for cash, rather than taking care to get the home's true value.
Sorry, where's the evidence about that number that you just gave us?
My lord, I don't have a separate witness statement because this was only received last night. I'm hoping you can take that from me on instruction. If you'd like, I can.
When was that? When were those sales efforts?
I don't have a date for that. Apologies, my lord.
Roughly?
Can I have a moment to confer with my client? I apologise for that. It's February of this year, my lord. So it is quite a striking reduction over a matter of 4 months.
So sorry, your client was trying to sell the property itself?
Yes.
Themselves?
Yes, my lord. The second, apologies. My clients were marketing the property for sale because, having seen the reality of the situation they were in, obviously any person in that position would want to understand, well, can we sell the property and try and get us out of debt? Their position at the moment is the property should not be sold, at least not at this time and for this price in this way. The second striking feature of the process for the sale is that it is an embarrassingly perfunctory process. Now, having received one offer, here is how the Building Society advertised the property going forward. We're looking at the italicised section of paragraph 15. Swansea Building Society is selling the property as mortgagee in possession, and an offer of £900,000 has been made for the property. If there is anyone else interested in purchasing the property, a higher offer must be made within 14 days of the date of this notice. and be supported by evidence of the financial arrangements available to fund the purchase. Closing date, 13th of July 2026, which I think is Monday. There's 3 points I'd like to make about that, my lords. First, this ad was placed on a particular real estate agent's website rather than advertised more broadly. So unless you were looking at a particular real estate agent's website, you wouldn't see it. Second, 14 days is plainly not a very long period of time. And thirdly, it's 14 days not just to see this house online, decide you're interested in it, inspect it, and decide to make an offer of it, but it's also 14 days to provide evidence of financial arrangements available to fund purchase. Now, even very wealthy people, my lords, usually don't have £900,000 burning a hole in their pocket, ready to pounce on real estate deals within 14 days. Even very wealthy people, even very sophisticated investors, would normally take some time to go to a lender to obtain terms for a mortgage in order to be able to buy that property. The sales process has effectively locked out almost everyone except the bidder who has already made the cash offer, or at least locked out a very large class of bidders who could drive the purchase price up. Now, my learned friend will no doubt say the court in hearing this appeal is limited to issues about the underlying stay order. You can't consider this other cause of action in determining whether to issue the injunction today. And we say that's just wrong. The court's power to issue the injunction is broad, its discretion in determining whether to issue the injunction is wide, and it can take into account these facts and this new evidence. And my lords, we made an injunction application. We didn't set out this as one of the reasons for the injunction because we only discovered these facts late last night. And we say the court can also take into account the reality that the sale is pending within 8 weeks, and it will be very difficult for Mr. and Mrs. Evans to have an injunction application heard on this ground or any other ground within that period. The reason for that is they're subject to civil restraint orders, so realistically what would have to happen is they would have to put in an application for permission to make an application. That application would have to be given the tick, and then there would have to be listed an application hearing on the injunction. And we say fitting that in would be very difficult. The second reason that the injunction should be granted is that if it's not granted, Mr. and Mrs. Evans will suffer irreparable harm in the form of the loss of their family home. Now, effectively, if the home is sold, their appeal and their efforts to set aside the possession order will be rendered pointless, and they'll have lost their ability to access justice. I take my Lord Justice Dove's point that in relation to the sale at an undervalue, the normal remedy is just damages for the difference in the value that should have been obtained and the value that was obtained. But we say this is their family home, and that is a special consideration that means that normally, that means that in this particular case, damages are not an adequate remedy for them. But on the other hand, the building society, the home is just an economic asset. And the loss of the ability to sell it for a relatively short period is a loss that's compensable in money's worth. The third reason the injunction...
It's not just the period, is it? It's that they may not, if this sale goes off, they may not get 900,000.
That is true, my lord, but we say it's very possible they'll get an offer of 1.2.
Your client has known for some time that they were marketing it at 880.
I'm not...
Is that right?
I don't have instructions on that.
Well, all right. It's been marketed for some time at 880.
Yes, my lord.
On a website.
I don't know how long it's been marketed for on the website, my lord. I can see SBS finally took possession of the property on 30 March 2026. That is about 3 months ago. I don't know at what point they actually started advertising it on the property. I'm hoping the respondent may be able to assist us with a date because it's not in the witness statement. While we clear up that particular factual matter, my lords, and I will ask my client at the relevant time if they know the precise date, the third reason we submit that the injunction should be granted is that it is just a relatively short-term order to hold the ring before a hearing in August or September. Now, earlier, the Building Society suggested that it would oppose the injunction on the basis that it hadn't had enough time to put in responsive evidence. They now have put in responsive evidence, and I don't understand that point to be pressed. But if they have more responsive evidence, if they have points they want to make, then they can make those points at the return date of the injunction. So for those reasons, my lords, we ask for an injunction preventing the sale of the family home in the meantime. My lords, subject to that point that I'm going to confirm with my clients in just a moment, the issue then would be whether you wish to hear the oral reconsideration arguments now.
Can I just go back to the first point on the injunction, the compelling new evidence, good arguable case, the home shouldn't be sold. So the evidence all goes to the question of the validity of the deed.
Yes, my lord.
Your clients receive £1 million or so.
Yes, my lord.
Against, at the very least, an agreement to provide a charge.
Yes, my lord.
Why is there not an equitable charge anyway in this case?
There is an agreement to, apologies. Step one, we say there is no equitable charge because the agreement to make an equitable charge being expressed in the form of a deed is still subject to the rule in Piggott's case. So we say that when the rule in Piggott's case renders a deed void, you are able to say, well, I would like my money back as money I hadn't received. You are not able to say the deed takes effect as a simple contract. And so for that reason, I would like to enforce it notwithstanding that.
But here, what actually happened was that there was an original agreement in 2018, and then there was a further arrangement in 2020 when the original money was repaid and a further advance was made. And in 2020, it was agreed that that further advance would be secured by the original mortgage. Now, if you're right in your technical points about there not being a deed, that in 2020 must have been an agreement that the arrangement would be secured.
I don't have an agreement, my lord, in any of the bundles about security for the arrangement in 2020. The way I understood the transaction working was that the Building Society simply looked at the earlier deed of charge, saw that the security under that would purportedly cover these further advances, and then didn't ask for a signature on a separate document in writing or as a deed.
Well, I think there was a separate letter which I've seen in somewhere in the bundles, signed by your clients, which referred to the earlier security as being security for the advance.
I don't have that letter in front of me, my lord. I can try and find it and make submissions on it. But we say that would be a point for consideration at the oral reconsideration stage.
Well, no, this is the injunction application. This is relevant to the injunction application. Good arguable case.
Yes, my lord, that's quite right. And so it's a point that goes to whether there is a good arguable case about the validity of the charge, but we say it's not a point that takes us below the threshold of a serious issue to be tried.
Well, yesterday, I don't know about everyone else, but I received something which I think was called a supplemental bundle in 5 tranches
Yes, my lord.
of PDFs.
That
And-
is bundle B, my lord.
Is that bundle B?
Yes.
Okay, so just trying to find. I've got a note that I've made that it's at page 207. I don't know whether that is accurate.
Bear with me, my lord.
14th October 2020.
14th
Yeah.
2020.
It's 210 on the PDF.
Yes, I can see the letter. It is signed by Paul and Jane Evans. I can't see a separate creation of security in it.
I've got a note that might be page 214.
214. Apologies, my lord.
Might have got the wrong
The heading is, "This is a legally binding mortgage offer to provide you with the mortgage described in this offer document."
Yes, my lord.
214 refers to the legal charge
Yeah.
already held by the society as
Yeah.
a condition of the loan at item 9.
Yeah,
Yes, my
so
lord.
that is, on the face of it, an agreement that this is a secured loan and that the security consists of the existing document which has been registered. Because that's actually a condition of for the payment of this second loan.
My lord, I realise that we're at the standard of a serious issue to be tried. I don't think the better view is that this box, clause 19, can itself be enough to give rise to a legal charge. Apologies, to an equitable charge. The reason I say that is that what's expressed in clause 19 is that the conditions for payment of the loan are about the receipt of the following documents in a form and substance satisfactory to us, and referring to the existence of the document, the first legal charge. And I say that that language is not of itself enough to say, if the first legal charge wasn't on foot previously, now we are agreeing that it should take effect.
But isn't that the substance of what's being agreed here? They're saying this is if one construes all of this in business-like terms, they're saying we're prepared to lend you this further money, which is up to £770,000, on the basis that it will be secured by the existing legal charge. I mean, otherwise this seems to be a completely pointless provision.
I see my lord's point. We still say that it is not clear enough to itself give rise to an equitable charge in the contingency that the legal charge is not on foot. And we say, my lord, that if the legal charge is void, it is at least arguable to be serious issue to be tried standard. You can't subsequently revive it by a document that's not itself expressed to be in a deed. It would, apologies, the void deed is a nullity that's not capable effectively of re-ratification between the parties.
It's not a deed, but it doesn't mean that the document is altogether void. It's just not a deed.
Apologies, my lord. We think it is arguable, at least to the serious issue to be tried standard, that that document couldn't take effect itself as a simple contract.
As a deed.
Yes, my lord. Because it's expressed to be a deed, we think it's at least arguable to the serious issue to be tried standard that it can't then be revived as a simple contract in light of defective execution and the rule in Piggott's case. And those are the points we would make at a trial of the action or on oral reconsideration about how that works. I apologise, my lords, for the fact that I'm thinking through some of these points for the first time.
Understand?
I am trying my best, and I'm taking the points your lordships are making to me.
No, we should make it clear we're very grateful you're here at all.
No.
Yeah.
My lords, I might take a moment to confer with my clients about the date on which the property was originally marketed, as far as they know about it. And when I come back, I might ask your lordships whether there's any further points you'd like me to address. So my lords, I
Sorry,
have...
just a moment.
Apologies.
Yes.
My lords, in relation to the marketing of the property, I've taken instructions from my clients. Apparently the situation is Mr. and Mrs. Evans were exploring selling the property to try and get out of this hole. They went to these agents and put it up for 1.2. Apparently the ad stayed continuously on after the building society took possession of the property from the agents. The price at some point was dropped from 1.2. My clients don't know the date on which that price was dropped. I'm sorry that I can't give you a more precise chronology than that.
Right, thank you. On the injunction application then, when it comes to balance and convenience, a critical question is usually where does that lie? And an answer given by most people applying for it is to say, well, it's covered, any potential damage to the other side is covered by my undertaking in damages. What's the position here?
My lord, we are willing to give an undertaking as to damages. I appreciate Mr. and Mrs. Evans being on universal credit means the ability to recover money under that undertaking is more limited than it might otherwise be. But we say that there is value in the house, ultimately, on top of the value that the Building Society says there is. And that store of value is something that might be able to compensate any damage that they suffer as a result of the injunction.
Right. That leaves then the question of oral reconsideration. We think we'd just like to hear from you. Is it where your best shot on? We understand entirely the difficulties you're in, but can you give us your best shot on the substance of it?
I can, my lords.
Yeah.
My lords, I'll do my honest best. This is the oral reconsideration of Mr. and Mrs. Evans' application for permission to appeal His Honour Judge Kemba KC's possession order. There's two grounds of appeal. We say that both of them meet the standard of a real prospect of success, which is not an overly high standard. And as your lordships know, it's the difference between a real prospect of success and a fanciful prospect of success. Both of the grounds that I'm able to formulate at this stage are Ladin Marshall grounds, and they're based on that fresh evidence that's emerged since the order. My lords, I appreciate neither of these grounds were put before Mr. Justice Ritchie in January 2026, but then neither of them could have been put at that stage because they hadn't been discovered yet. So I do ask your lordship's permission to raise these grounds at this stage, now that Mr. and Mrs. Evans do have legal representation and do have the evidence that can support them. The first ground is the fresh evidence in relation to witnessing. As I've explained, my lords, there is fresh evidence that the person who purportedly signed this deed, attested to the deed, Vicky Henshaw of 103 Newton Road, did not actually do so, because when she was reached for the first time, she gave the answers that I've read out in Mr. and Mrs. Evans' witness statement. Indeed, if she did sign it, apparently she's forgotten her own address. Now, we say that fresh evidence satisfies the 3 requirements in Ladd and Marshall. First, it was not available earlier because Ms Henshaw has only just been found. Second, it is apparently credible because it's quite difficult to see why Ms Henshaw would lie about witnessing the document, and her evidence that she didn't witness it is consistent with Mr and Mrs Evans' evidence that they never attended a signing meeting like this where she could have witnessed a document. I appreciate, my lords, that the requirement for credible evidence is more than just merely arguable, and I apologise that I don't have a witness statement from her setting it out clearly. I only have the account of the conversation over the phone with her.
How long have your clients had the mortgage document? Do you know?
The mortgage document itself, my lord, they've had for some time, as in the corrected version. They haven't had the conveyancing file, which had the original version and the correspondence to and from the land registry, which showed that there was the effort to correct it.
Yes, so that's the correction point, but the signature point, the document in their possession had Miss Henshaw's attestation on it.
Yes, ma'am. Right. But they haven't been able to reach her until April 2026.
No, but I think part of your case is that they were certain they never went to such a attestation signing meeting, so they must have known all along it wasn't correct, if that's right.
Yes, my lord. Apologies. When I talk about fresh evidence, what I'm talking about is not that the point per se is new. I'm talking about now they have fresh evidence in support of the point that the deed was never properly executed. And that the fresh evidence is from Ms Henshaw herself. In relation to the third Latin Marshall criteria, my lords, it's that it would have an important influence on the result of the case. If His Honour Judge Kemba KC had known there were good reasons to think the charge was invalid, he would have been significantly more likely to grant a stay of the possession order, at least until that point could be cleared up. The second ground is fresh evidence in relation to alteration after execution. As your lordships know, in the rule in Piggott's case, the intentional material alteration of the deed after execution without each party's consent renders the deed void. There is fresh evidence that it was altered after execution. These changes were intentionally made, and we submit they were material changes. As explained in Chitty, the line is, in order to show that the alteration is material, the would-be avoider should be able to demonstrate that the alteration is one which, assuming the parties act in accordance with the other terms of the contract, is one which is potentially prejudicial to his legal rights or obligations under the instrument. And we say it was a material change to convert an instrument which could not be registered with the land registry into one which could be. And that was prejudicial to Mr and Mrs Evans' rights over the land.
But they'd agreed to give the charge. They signed it.
Yes, my lord.
So how is putting their name in so that registration can be perfected prejudicial to their rights?
Because, my lord, if you, apologies, to take the counterfactual as highest, that there was an equitable charge over the home as opposed to a legal charge expressed in a deed registrable.
No, sorry. Let's leave aside the other point about witnessing.
Apologies, my lord.
So we're starting here on the assumption that they've signed something intending to deliver it as a deed to the mortgagee in order to secure the advance. That's what they've intended to do. The mortgagee then seeks to have it registered. In fact, it's the solicitor acting for both the mortgagee and the mortgagor attempts to have it registered, and the registry says, well, we can't read the signature. The solicitor then just adds their names and scrubs out the signature which shouldn't be there. How is that a material change that prejudices your clients? They've agreed to give this charge, and all that's happening is that the mechanics of registration are being carried out.
The material change, my lord, is that a charge that is not registered and is not registrable is not as prejudicial to their position as a charge that is registrable and is...
But they agreed to give it.
Yes, my lord, but it's the distinction between having agreed to give something and that thing actually being legally effective. We say there's at least a real prospect of success in saying that the difference between those two things amounts to prejudice.
Are you saying, I think, that they've now got the money, and therefore, having got the money, they're prejudiced by not being able to rely on an argument that there's no valid charge?
Yes, my lord, and I appreciate that ultimately the Building Society may want to make personal claims against Mr. and Mrs. Evans, but we say that there is a prejudice and a difference between being subject to personal claims for money and those personal claims being secured by a deed of charge over one's home. In relation to the point about consent, my lords, my lord, I've said all that I can in relation to the scope of the solicitor's retainer, and in particular the timing point. In fact, Mr. Forsyth relies on a different point for consent, as I understand it, and it's a clause within the deed of charge itself. Might I show your lordships that clause? It's at Bundle E, the most recent bundle, page 98. And I apologise, when I refer to a page, we are looking at these small numbers in the very bottom right-hand corner, behind tab 4, page 99, clause 17, headed Power of Attorney. Are my lords with me on that?
Yep.
My lords, this is clause 17, the Power of Attorney clause. On my learned friend's case, it might as well be called clause Henry VIII, because he says that this clause in the deed of charge allows the Building Society to sign and amend the deed of charge itself. There's at least 4 problems with that, and we say all of them reach the standard of a real prospect of success in resisting that argument. Problem number 1, we say, of course, the deed of charge wasn't validly executed, so it can't create this power of attorney. Problem number 2, conceptually, I don't think you can agree in a contract or a deed to allow another party to unilaterally vary and re-sign that contract or deed. That goes beyond even an agreement to agree. It's an agreement to do whatever you tell me to from time to time. It's not enforceable. Problem number 3, I don't think this clause is actually intended to be a Henry VIII clause. Henry VIII clause is a really extraordinary sort of clause. It would need to be spelled out really clearly. What this clause says is that the Building Society can sign, seal and deliver, execute as a deed or otherwise perfect any deed, assurance, agreement, instrument or act which may be required or deemed proper for any of the purposes referred to in or otherwise in connection with this charge. It doesn't actually say you can amend and re-sign this charge itself. It's talking about other documents. It's not far away from a further assurances clause. The 4th reason we say my learned friend can't rely on this clause is that a clause of that sort in a consumer mortgage would not be binding under Section 62 of the Consumer Rights Act 2015. It'd be unfair because, contrary to the requirements of good faith, it would create a significant imbalance in the parties' rights and obligations to the detriment of the consumer. So we say my learned friend doesn't have a get-out-of-jail-free card in relation to consent in that way. Now, I want to anticipate 2 other arguments that my learned friend may make to try and say that the oral reconsideration doesn't reach the standard of a real prospect of success. The first argument is the argument that because possession of the home has been taken, there's nothing left to stay and the appeal is pointless. And my lords, I've given you our position on that, that even though a stay of the order wouldn't reverse possession, it nonetheless would have some practical effect. There is something to fight over. The second argument I anticipate from my learned friend is that seeking a stay of the possession order in separate proceedings was the wrong procedural route for Mr. and Mrs. Evans to follow, that they should have tried to set aside the possession order for fraud or tried to make a second appeal under CPR 52.30. And I'll point out, my lords, that Mr. and Mrs. Evans have now done that. But more importantly, in choosing the wrong procedural route, they are litigants in person, apologies. At that stage, they were litigants in person trying to save their home. To the extent they've chosen the wrong procedural route, not knowing that that's erroneous, we ask the court to grant relief, notwithstanding the error, especially as now they have, in one case, made, and in another case, set out their intention to make the correct procedural applications. So for those reasons, my lords, if you were minded to determine oral reconsideration today, we say those two grounds of appeal have a more than fanciful success. If, my lords, you were minded to defer oral reconsideration to another occasion, I've done my best today, but I think I can do even better. My lords, is there anything further I can assist you with at this stage?
No, thank you very much, Mr. Strand.
Thank you, my lords.
Mr. Forsyth, yes. So I think that the two live issues are perhaps three, but should we go into the oral reconsideration at all, or should it be deferred to the hearing that's coming up anyway before a High Court judge?
Indeed, my lord.
And secondly, the injunction.
Indeed, I'm grateful. The way I propose to address this, my lords, is by starting with our submissions as to why, just purely on a procedural level, the oral reconsideration should be heard and dismissed by yourselves, constituting yourselves as the High Court today. I'll then address you on the injunction application, and within that, I'm proposing to flesh out some of the more detailed points about the merits of the proposed oral reconsideration that my learned friend has just been discussing. So, my lord, as you've heard, our position is that the oral reconsideration should be heard and dismissed today. As a starting point, and as my Lord Justice Dove has noted, that appeal is still not properly constituted. There is no transcript and there is no compliant appeal bundle, despite the fact that that was one of the reasons given for dismissing the application and indeed marking it as totally without merit by Mr. Justice Ritchie on the 20th of February this year. The appellant's efforts to obtain a transcript remain, respectfully, obscure, and I would note that Mr. Evans has been successful, I should say Mr. and Mrs. Evans, has been successful in obtaining transcripts on at least two other occasions in these proceedings. Those were the hearings before Deputy District Judge Wilson in July and September 2024, and they are enclosed at the back of the ancillary bundle, aka Bundle D. The appellant's position for many months, until I spoke to my learned friend on Monday afternoon, was that the oral reconsideration should simply go ahead today. We were served with their ancillary bundle for the first time in the afternoon of Tuesday, July the 7th. And can I take you to that bundle now, my lords?
So sorry, can you remind me which one this is?
So this is the
Oh,
ancillary bundle, my lord, that's also referred to as Bundle D, confusingly or otherwise.
Yeah.
I'm grateful, my lord. So if we start at page 7, this is a draft order enclosed with the appellant's reconstituted application. And at paragraph 5, the appellants say that the issue of whether the possession orders dated the 20th of September 2024 as amended on the 2nd of January and the 23rd of October be set aside, and what further consequential relief, including the immediate restoration of possession, be given, shall be determined at the hearing on the 16th of July this year. And then if we turn to page 14, in the appellant's witness statement, paragraph 30, the point is made even clearer. we ask the court to set aside the order from Mr. Justice Ritchie dated the 24th of February on terms that do not remit any matter to a lower court. That was their stance, knowing, as, if I can put it this way, seasoned litigants, that there was going to be a hearing impinging upon this court's resources today. Now, I'm conscious of the fact that my learned friend was only instructed on Monday, but that does not excuse his client's failure to put together an appeal bundle with a transcript in the previous some 4 or 5 months, 4.5 months. Litigants in person are bound by the civil procedure rules like anybody else. Additionally, my lords, we say that the permission to appeal application has also now been overtaken by 2 separate events. The first event is that the possession order has now been enforced. As my lords have heard, His Honour Judge Kember was merely asked to stay the possession order. And even if the appellants were somehow able to resurrect their attempt to appeal, or seek permission to appeal, His Honour Judge Kember's decision, they can get nowhere within the confines of that appeal by asking this court to grant a stay on the possession order. Once a warrant for possession has been executed and a mortgagee has taken possession, the court's power to stay enforcement of the possession order is simply lost. There is no ongoing process to halt. And in support of that proposition, my lords, can I take you to an authority in the bundle that we passed up this morning? It's a relatively slim bundle. And this is at page 17, being the Court of Appeal's own decision in the case of Zaytoun and Town Route Limited, Town and Country Building Society. I should say, to the extent it's considered relevant, this was the Court of Appeal sitting with a 2-judge bench. It's not reported, but we've obtained a transcript which begins at page 16. And then if I can take you to the bottom of page 17 and just read out this paragraph. An application was duly made to the master for leave to issue a writ of possession. The master gave that leave. Mr. Justice Alder subsequently upheld the master's decision. The writ of possession was then duly issued and it has now been executed. I understand that was done yesterday when possession was taken. Mr. Raja and his family moved out of the property. Mr. Raja now seeks, as I've mentioned, to be restored to possession. And this is the crucial bit, my lords. It is clear that it is now not possible to grant any order by way of a stay of the order for possession. That order has been duly executed. Possession has been taken in pursuance of the order. There is now therefore nothing to stay. Now, I'm conscious my learned friend would say that there is the alternative route of either applying to reopen the appeal against the possession order or setting aside the possession orders on the basis of fraud, but those are 2 separate routes by which the appellants can and indeed are actively seeking that relief. And it's not appetite for them to do so within the confines of a reformulated appeal against His Honour Judge Kember's decision. The second event, my lords, that we say renders the appeal overtaken by events, concerns the striking out of the 3rd claim on the 30th of June this year. As you're aware, the permission to appeal application before Mr. Justice Ritchie was directed towards His Honour Judge Kember's refusal last December to grant a stay pending the 3rd claim brought by the appellants. So the stay was parasitic upon the progress of the 3rd claim. And as that 3rd claim has now recently been struck out, the entire PTA application has been overtaken by events. Now, my lords, I'm conscious that my learned friend suggests that the appeal against His Honour Judge Kember's decision might now be reformulated on a different footing. And it's accepted that in jealously guarded circumstances, the court may allow new points to be raised on appeal. But we say that the appeal cannot properly be recast by reference to a hypothetical application which was not even before His Honour Judge Kember, particularly when the appellants have the alternative option of seeking relief within the confines of the fourth claim. And the appellants have not sought or even intimated that they'd be seeking permission to amend either of the application notices which were before His Honour Judge Kember in December 2025. So, given the amount of procedural traffic over the past 2 years, my lords, and I appreciate if some of these points are familiar to you already, it is, I think, worth reminding ourselves what the January PTA application and with it the oral reconsideration was about. The appellants, as you've heard, sought permission to appeal the order handed down by His Honour Judge Kember on the 16th of December, following a hearing on the 12th of December. 2 applications were before the court at that hearing. They are visible at Bundle C, aka the application bundle, page 29, and page 78.
Sorry, the application bundle. Oh yes, the N244 application.
I'm grateful, my lord.
Yes.
So this is the application dated the 11th of November, and then
Sorry, which page?
29, my lord.
I got a second
Sorry.
your letter.
Yeah, that doesn't seem right.
My lords, excuse me. My lords, please accept my apologies. I should have directed you to Bundle B rather than Bundle C. So this is the supplemental bundle.
Still page 29.
Still at page 29 in the bottom right-hand corner.
Yep.
And whilst that application notice did refer to post-judgment fraud evidence, there wasn't, at that time, no claim before any court which actually sought to set aside the possession order on the basis of fraud. And so far as the appellants wish to raise any points concerning the charge's validity outside the confines of either an application to set it aside on the basis of fraud or reopening that appeal, they were bound by cause of action estoppel. And then the second application that was before His Honour Judge Kember is at page 78 of the same bundle. The application notice here is somewhat confusing because it begins by saying that it's asking the court to set aside the order dated the 25th of November, and then vary it to order the stay of enforcement of the order dated the 23rd of October. So again, this is still directed purely towards a stay of the order refusing permission to appeal, and then an order for cross-examination which hasn't been challenged on appeal.
Sorry, what was the order 23rd of October?
That was Judge Kember again, wasn't it?
My lord, yes. That was... I'm not sure that's in any of the bundles, but from memory, and you'll have to forgive me for this, I think that was a procedural order refusing... That was an order refusing to hear a separate application which had been brought in similar terms. So that, and I could look into this point, but that was the focus of the order dated the 25th of November, to our understanding. Now, the appellants had already tried and failed to appeal the possession order by the time they were before His Honour Judge Kember in December. In fact, a rolled-up permission to appeal hearing had already taken place before the same judge on the 23rd of June that year, where the only ground which was pursued related to the operation of the slip rule, There were other grounds, including that sought to advance fraud, but they were not pursued at the hearing. That judgment was handed down refusing permission on the 23rd of October, at which point the judge also refused yet another 11th hour application for a stay. My learned friend has, in his written submissions, alluded to the fact that the appellants then tried and failed to appeal His Honour Judge Kember's order refusing permission to appeal by making a further application, which was dated, I think, the 13th of November 2025. Now, that application was dismissed and marked as being totally without merit by Mr. Justice Michael Green in December 2025. I can take you to it. It's at the back of the latest bundle, Bundle E. You can see the grounds of appeal that were advanced. And also Mr. Justice Michael Green's order. But the key point can be put succinctly. That permission to appeal application could never have sought to appeal His Honour Judge Kember's refusal to grant permission to appeal against the possession order, because as Mr. Justice Michael Green noted in his order certifying the application as totally without merit, there is no appeal against a refusal of permission to appeal. If you need authority on the point, my lords, that's in section 54 of the Access to Justice Act. So when those two subsequent applications came before His Honour Judge Kember on the 12th of December, they were not even asking him to reopen their attempt to appeal the possession order. That had already failed. And we say it's not open to the appellants to reframe, after the event, the January PTA application as if it was against a different order, namely the possession order, or indeed as if it concerned the judge's failure to grant an entirely hypothetical application, for example, one that didn't seek a stay, and one that wasn't parasitic upon the third claim, which they might have issued last December if they had the new evidence upon which they rely today and had already commenced the fourth claim. And nor have they attempted to grapple with the cause of action estoppel, which would otherwise have bound the parties, and indeed His Honour Judge Kember, on issues relating to the charge's validity. So, my lords, we say that the proper route to pursue any argument seeking to set aside the possession order on the basis of fraud, whether they relate to the point about Miss Henshaw's witnessing, or indeed the alteration, ought properly to be pursued within the context of the fourth claim, rather than as a artificially reconstructed appeal against His Honour Judge Kember's order from December last year. Now, shortly after the appellants commenced their fourth claim, in late March 2026, they did try and fail to obtain yet another order staying the enforcement of the possession order. That was dismissed by His Honour Judge Kember, and that precipitated, I should say, the extended civil restraint orders that were made by that judge on the same day. But it is open to them to try again, if they so wish. They have had the application on which they rely, the evidence on which they rely today, since the 13th of April this year, in the case of Miss Henshaw, or the points around Miss Henshaw, and the 26th of May 2026, in respect of the points which they say are raised by the file disclosed by DJM, where the only material new evidence is the correspondence with the Land Registry about the requisition. It was entirely open to them, once they received either or both of those items of new evidence, to make an interim application within the fourth claim, saying that there was now new evidence which established a seriously arguable cause of action justifying the setting aside of the possession order on the basis of fraud, and then seeking injunctive relief on that footing. They have failed to do so, notwithstanding the fact that their litigation activity has remained fairly busy in that period. They contested what was ultimately an adjourned hearing on the 12th of June 2026, and also unsuccessfully resisted the strikeout application in the third claim on the 30th of June. The fact that the appellants have been without representation until Monday, if I can put it like this, has not historically served as a check upon them in issuing new applications or claims. They've always been exceptionally energetic in that department. And we say that the reason why they've not taken that much more orthodox route, and instead tried to pursue it in the confines of this appeal, is a transparent attempt to circumvent the extended civil restraint order which has been made in the fourth claim, and in the County Court and High Court, and concerning matters touching upon the dispute. That's the reason why this application has been brought today, particularly for an interim injunction. And that's the reason, in substance, why they're now pursuing the same relief within the context of the oral reconsideration, notwithstanding the fact that the original appeal itself has been wholly overtaken by events. So, my lords, we say that for those procedural reasons alone, and before one even gets into the meat of the new evidence and the new allegations, the oral reconsideration can simply be heard and dismissed today. Now, if it would be of assistance, perhaps it would be best if I address you, as I've said, on the points of detail concerning the new allegations, alongside our submissions in response to the injunction application. And that's where I'll turn now. So, focusing on this injunction application, my lords, my learned friend has identified 4 potential routes for such an injunction. For the avoidance of doubt, our position is that no seriously arguable route to an injunction lies through either the oral reconsideration, CPR Part 52.30, the fourth claim, or the undervalue point, which has been raised for the first time today. I've already addressed you on the points about the oral consideration. As to CPR 52.30, that does not apply to an order which has been made in the county court, and the possession order in this case was made in the county court. And as to the undervalue point, this was not even mentioned in the application notice, which was belatedly raised on Tuesday afternoon, which is now being heard with the court's indulgence today, nor was it advanced in the quote-unquote final representations filed by the appellants late on Tuesday this week. It was raised for the first time this morning. But, my lords, we actually need not get into any of that, into the seriously arguable cause of action issues, far less the substance of the new evidence or allegations themselves. And that's because the injunction application cannot get off the ground in circumstances where the cross-undertaking put forward by the appellants for the first time this morning is evidently of extremely little worth. As demonstrated by the Building Society's latest witness statement, which I can take you to in due course, and I think it's fair to say tacitly acknowledged by my learned friend today, the appellants are highly impecunious individuals.
I think that's a given.
It is a given,
yes.
Indeed, my lord. And an injunction granted today of any duration would cause serious and irremediable prejudice to the Building Society. Again, as I'll explain by reference to the witness statement, a sale has now been agreed to a cash buyer above the initial marketing price. A notice inviting higher offers was on the estate agent's website, and I should also say on instruction, and if I'm allowed to say so with indulgence, on my own searches, the property was also marketed on Rightmove as well. And the notice inviting higher offers expired on Monday. Solicitors have been instructed, and they estimate that the sale could complete within 8 weeks. So in those circumstances, and for reasons that I think will be readily appreciated by the court, an injunction granted today, at this stage of the cash sale, could have catastrophic ramifications for that sale, leaving the Building Society facing yet further delay and the prospect of having to sell to a different buyer at a lower price. And in a sentence, my lords, the appellants are no good for that risk. So to develop those points, and I appreciate that impecuniosity is cast as common ground, can I take you to Bundle E, aka the bundle filed yesterday, and the witness, and page 276 is the witness statement filed by Mr. Mark Hughes, a mortgage administration manager at the Building Society yesterday. If we start with page 278, paragraph 16. Actually, perhaps it's better to start on paragraph 14. SPS finally took possession on the 30th of March 2026. It bears emphasis at this stage, my lords, that one of the three events of default identified by the Deputy District Judge in this case was the unauthorised demolition of the property. Now, I understand that the appellants continue to live on site in a smaller structure, but as Mr. Hughes states in his witness statement at paragraph 14, the property is, for practical purposes, now a building plot. Now, in those circumstances, the Building Society took appropriate marketing advice, he says, and placed the property on the market, inviting offers over £880,000. Now, I have it on instruction today that the property went on the market shortly after the 3rd of June 2026. My lords. An offer of £900,000 was received by the Building Society. The Building Society then instructed its marketing agents to place this notice that you can see on their website before accepting the offer. This invited higher offers within the 14-day notice period. That notice period expired on Monday, and solicitors were instructed on Tuesday. Now, as you can see, the proposed sale is for £20,000 above the initial marketing price. It is to cash buyers, and the Building Society's position in witness statement on the understanding of their solicitors is that completion could take place within 8 weeks. So that's the situation in terms of the sale. In terms of impecuniosity, can I take you to, again, paragraph 16? The total amount outstanding on the mortgage account is at least £1.037 odd million. Mr. Hughes notes that this is not a redemption figure, and it does not include legal costs post the 8th of May 2026, nor does it include the costs of marketing and selling the property. And if you scroll up to paragraph 13, apologies, you'll see that the legal costs from the 9th of May this year to the conclusion of this hearing are estimated to be in the region of £60,000. On any view, my lords, the loan arrears would remain outstanding even if the appellants were somehow able to set aside the possession order and obtain declaratory relief that the charge was void. Even if the loan was unsecured, it would still be a loan. And it's also worth recalling that the loan in question was advanced as a remortgage in 2020. And as you've heard, the remortgage application form did include a signed representation that the remortgage was subject to a first legal charge. So drawing all those points together at paragraph 16, Mr. Hughes estimates that, assuming a completion in September 2026, the appellants will still very probably owe the Building Society more than £200,000 on an unsecured basis. And they would do so in circumstances where, as confirmed at paragraph 11 of his witness statement, the appellants have not even made any payments to service the interest on that loan since May 2024. So, my lords, that's the appellant's impecuniosity as between it and the Building Society. But there's more. If I now turn to paragraph 17, page 279, there are 7 further factors. First, as is common ground, or at least as is said by the appellants, they're now in receipt of universal credit. We make no admissions as to the basis on which they might have obtained it, but that is their own position. There are, as Lord Justice Zacaroli has already noted, other charging orders secured against the property. and they relate to cost orders made against the first appellant, Mr. Evans, in separate litigation, in sums totalling over £140,000. My instructing solicitors understand, and it's covered in the witness statement at 17.3, that the one or both of the appellants have also had judgment entered against them in separate proceedings brought by Bath Demolition Limited in Bristol. Yeah, there's yet more at 17.4. A claim brought by Mr. Evans against Security Law Limited was struck out in May 2026 with costs orders. 17.5 addresses the third claim that you've heard so much about. It's worth remembering that the Building Society was not the only defendant to the third claim. Obviously, the Building Society is relying upon its cost indemnity for its own costs of that claim. But the claim was also brought against DJM solicitors. DJM also succeeded in getting the claim against them struck out, and a final order on costs is awaited following submissions, but DJM's schedules of costs totalled over £50,000. The appellant's mortgage application forms referred to two companies to provide comfort about their financial position. They have both been wound up. And also, bank statements disclosed by the appellants during the course of the litigation revealed that the £300,000 that was advanced by way of remortgage was actually used in substantial part to fund their lifestyle. And that may be why we could draw the inference the property remains a building site today. So with that in mind, my lords, the appellants are in no position to offer this court an unlimited undertaking with any teeth. And that alone is fatal to their application for an injunction. The balance of convenience is tipped starkly against the granting of relief, not least given that a sale of the property is now very close to being concluded. Now, today, for the first time, my learned friend has submitted that the property might be worth more than £900,000 and the sale might be at an undervalue. It's then suggested that this might constitute a freestanding basis for granting an injunction, notwithstanding that it didn't appear in the application notice or in the quote-unquote final representations. This is the appellant's own injunction application, brought at a late stage on Tuesday afternoon, and it's the latest in a long line of interim applications. Those final representations identified 3 potential routes, and this was not one of them. And for that reason alone, we say that the court is in no position to grant an injunction on that 4th basis today. But if that's not enough, and I'm sensitive to the circumstances surrounding the learned friend's instruction, he is unable to take you to any documentary evidence today in support of his client's contention that the sale might be at an undervalue. In those circumstances, the court's unable to place any material weight upon the contention. The facts are that the Building Society took advice from a marketing agent who said it should go on the market, inviting offers over £880,000, and an offer was received for £900,000, and no further offers were received during the notice period. My learned friend refers to the appellant's own attempts to sell the property, first at £1.2 million, and then it appears the price was dropped, although we don't know to what level. I understand it's common ground, although I'll be corrected, that no offers were ever received at that level. Certainly no evidence is before this court of any offers being received at a level above £900,000. And finally, my lords, and I appreciate that this isn't in the bundles, I have it on instruction that the Building Society obtained its own valuation in December 2023, which valued the property at £800,000. So in those circumstances, £900,000 is a good price, and it's been undertaken following a fair process. And as a last point on the balance of convenience, my lords, we say that the severity of the irremediable prejudice that the Building Society would face if an injunction was to be granted today would only be compounded by the delay and expense which it has already had to incur. The possession order in this case was obtained on the 20th of September 2024. Mr. Hughes's witness statement lists a grand total of 19 attempts to prevent the enforcement of that order up to the end of March 2026, when it finally was enforced. Since that date, the Building Society has had to expend yet further costs, successfully striking out a separate abusive claim brought by the appellants. That's the third claim. And the appellants are correctly subject to extended civil restraint orders in the County Court and High Court. So on that basis, purely on the basis of the lack of an undertaking with any value and the balance of convenience, we respectfully submit that the application for an interim injunction must fail before there is any consideration necessary of the serious issue points. My Lords, if it will be of assistance, I can now address you on those serious issue points. As I've alluded to, we're now at 4 potential routes.
Can I just inquire about timing? Because we need you to finish by lunchtime. We only need your headline points, I suspect. How long will it take you?
I think I'd probably need 20 minutes, my Lord. I can try and be done in 15.
Okay, take it as quickly as you can. We're happy to sit a few minutes later than 1 o'clock. But
I'm grateful, my Lord. I will be as quick as I can. Because I think a lot of these points have already been really covered off already. So there are 4 routes: the oral reconsideration, the 52.30 application, the 4th claim, and the undervalue point. I don't propose to say anything further about the undervalue point. It's not in the application notice. I've also addressed you on the fact that the application notice itself seeks a stay in the alternative to an injunction. I think that point's already been canvassed between your lordships and my learned friend. I will address you on the Zaitoon authority. I won't go any further there. My Lord, you've heard our submissions on the oral reconsideration. Even if you were persuaded that there ought to be a deferral of that oral reconsideration to give my learned friend another opportunity to, as he says, put his best foot forward, it still would not follow that there'd be a seriously arguable basis for finding that an oral reconsideration of the orders in question could ultimately support an injunction prohibiting the property's sale. And I've addressed you on that point already. In a sentence, His Honour Judge Kember was only, as far as is material, asked to grant a stay pending a claim which has now been struck out. The next alternative proposed by my learned friend is to grant injunctive relief pending the determination of their new application under CPR Part 52.30. With respect, this also does not leave the ground. As you know, the possession order was made by Deputy District Judge Wilson sitting in the County Court at Swansea in September 2024. Permission to appeal that order was ultimately refused by His Honour Judge Kember in the same court. Now, it is correct that His Honour Judge Kember's order refusing PTA also lifted the stay on that order and required the appellants to give up possession of the property by the 30th of November 2025. But that is not a possession order which could sustainably be appealed in its own right. It merely followed on as an inexorable consequence of the learned judge's decision to refuse to grant permission to appeal against the possession order. Now, as I think might be well known to you, 52.30 subparagraph 3 states that this rule does not apply to appeals in the county court. Now, the grounds of appeal accompanying the CPR 52.30 application only refer to a proposed application to reopen an appeal against the possession order of Deputy District Judge Wilson. So those orders are only county court orders. The draft order accompanying that application does refer to the order of Mr. Justice Michael Green, dated the 11th of December, refusing permission to appeal against the possession order. But with respect, and as I've noted briefly earlier, that is a red herring. On that date, Mr. Justice Michael Green dismissed the application for permission to appeal the order dated the 23rd of October. As I've said, to the extent that the order on the 23rd of October granted a possession order, or made a possession order, that only followed as a consequence of the decision to refuse permission to appeal. And as you all know, under the Access to Justice Act, no appeal may be made against a decision of the court under this section to give or refuse permission. So whatever new evidence the appellants might have been able to put forward in that application determined by Mr. Justice Michael Green on the 11th of December, the learned judge would not have been able to reopen an appeal into either the original possession orders granted by Deputy District Judge Wilson or His Honour Judge Kember's refusal of permission to appeal. And if it needs any further support, and I won't take you to it given the time, the points addressed by Mr. Justice Michael Green at paragraph 5 of his judgment dated the 11th of December 2025. That's at the back of Bundle E. So there is no viable route for a CPR 52.30 application which goes through either the County Court orders or Mr. Justice Michael Green's order to supply injunctive relief. And there is one final reason why CPR 52.30 also cannot work and cannot supply an injunction today. And that is that under CPR 52.30 subparagraph 1c, a final appeal cannot be reopened unless, and I quote, there is no alternative effective remedy. On the appellant's own case, they must have an effective alternative remedy. They have already brought and are pursuing separate proceedings, which are not before this court today, which seek to set aside the possession order on the basis that it was obtained by fraud. If that claim is meritorious, that must constitute an effective alternative remedy, which prevents the court from exercising its jurisdiction under CPR 52.30 from reopening any final appeals. So, Judge, that's 52.30. Apologies, my lords, that's 52.30. I'll now address you on the fourth claim itself, which also shades into the points of detail about the oral reconsideration. As you've heard, our headline point on the fourth claim is any applications for injunctive relief in support of that claim ought to be brought within that claim, and this is a transparent attempt to circumvent the ECRO. And even if that was not enough to render the application an abusive process in its own right, it would constitute a powerful discretionary factor against the court granting an injunction in support of the fourth claim today. But in addition, the points of underlying merit concerning Ms. Henshaw and the alteration also go nowhere. So starting with Ms. Henshaw, as you've heard, her name has been on the charge as the witness since the inception of these proceedings. At this time, and the reference to this is page 81 of Bundle E, Ms. Henshaw was employed as a receptionist in the offices of the appellant's then solicitors DJM. The charge, including its amended signature blocks, are not new evidence, and they were at the heart of the possession proceedings. If the appellants considered that they had not signed this charge, or indeed if their signatures had not been witnessed, whether by Ms. Henshaw or anybody else, they were open to advance this allegation in their defence to the possession proceedings. Who could be in a better position to say whether Mr. and Mrs. Evans signed this charge or had it witnessed than Mr. and Mrs. Evans themselves? Yet they put in a 10-page long defence to these possession proceedings and made no mention of the point at all. Indeed, if I can take you to the supplementary bundle, Bundle B, page 11, paragraph 2 towards the bottom. Maybe in the interest of time, we should just deal with this as a point for your reference. The defence effectively admitted that a charge had been badly executed in 2018, contending that the remortgage was, and I quote, a further advanced loan of £300,000 pursuant to the existing 30-year mortgage that was in place with the claimant. Now, whilst this characterisation of the remortgage was nonsensical, it was predicated upon a prior charge being in place, quote unquote, as of 2020, No points were made about this charge being executable rather than legal. And the charge could only have been in place, as they say, if it had been validly signed and witnessed. And then over the next 3 pages, at pages 12 to 14 of Bundle B, I should say the appellants went on to plead a long-winded defence of estoppel and waiver. In a sentence, those defences were premised, on any ordinary reading, upon there being valid pre-existing legal rights which were capable of being estopped and waived. So no point was made about signing or witnessing in the defence of the possession proceedings. And it was only when, having exhausted their first collection of unmeritorious defences and had a possession order made against them, the claimants put in a document described as a notice of additional claim on the 30th of January 2025 that they began to advert to the fact that, as they said, DGAM used and or obtained an unknown, unverified witness. Those arguments were then ultimately abandoned for His Honour Judge Kember on the 23rd of June. Now, my learned friend has made a point about Miss Henshaw concerning her address and the fact that it was, as he says, at 42 Ford Taliesin and not 103 Newton Road as stated on the charge. The point has been raised on more than one occasion before, and I appreciate my learned friend wasn't there, but the answer remains similarly banal. 103 Newton Road was the address of Miss Henshaw's employer, DJM. And the reference to that is page 65 of the application bundle, Bundle C. Miss Henshaw was perfectly entitled to use her professional address rather than her personal one. None of that could constitute a seriously arguable basis for even suggesting that the charge was invalidly executed or that some wrongdoing or something of any suspicion had taken place in connection with its signing and witnessing. And then, of course, as I'm sure my lords will be very familiar with, there is no requirement anyway to state a witness's address under the Law of Property Miscellaneous Provisions Act 1989. The point's not suggestive of any conscious or deliberate dishonesty on SBS's part, and nor could it have been material to any impugned orders. So that's the address point about Miss Henshaw. The second point concerns the appellant's contention that they cold-called Miss Henshaw on the 13th of April 2026, asked her if she'd signed the charge back in 2018, and obtained a denial of the same. Now, their account of this call remains entirely uncorroborated. I put it no higher than this. It would not be particularly surprising if Miss Henshaw had reacted in this way to an unheralded call from 2 people about a document signed more than 7 years previously. And it bears emphasis that the appellants have seemingly taken no steps over the past 3 months since that phone call on the 13th of April to obtain any sort of witness evidence in Miss Henshaw's own hand, or even, so far as we're aware, make contact with her again. So on that basis alone, we say there's no seriously arguable basis for alleging conscious and deliberate dishonesty on SBS's part. It's also not alleged, I understand, that any officers or agents of SBS were personally privy to the charge's execution. Now, I'm conscious that there's no witness evidence that addresses this point directly, but in circumstances where the charge had Miss Henshaw's name on it, and neither the signature nor the witnessing had been gainsaid by the appellant at any point between its signing in December 2018 and their first notice of additional claim in January 2025, it is fair for this court to conclude that SBS's belief that the charge was witnessed by Miss Henshaw was based upon the fact that Miss Henshaw's name was on the document and the fact that it hadn't been gainsaid by the appellants. So on that basis alone, once again, the appellants are unable to meet the test into Takar and Gracefield or refashion this into a seriously arguable point by way of oral reconsideration. The next broad category of points, and this is the last broad topic I'm proposing to address, is the alteration argument. As you've heard, the party solicitor, Ms. Kelly, clarified the signature pages in circumstances where the claimants had each signed twice in error. We say that this case is very far removed from the rule in Piggott's case, even on a serious issue to be tried basis, not least because the alteration was made with the party's authority. Taking a step back, my lords, the appellants had applied for a mortgage which was to be secured by way of a registered charge. They engaged DJM as their solicitors in that transaction. And putting the points aside about Ms. Henshaw to one side, the appellants signed that charge. In fact, they did so twice. The loan is advanced, the sale completes, and they purchase the home. After that point, the Land Registry asked for clarification to the charge merely so they can identify whose signature was whose. Quite plainly, the very act of engaging DJM to act as their conveyancing solicitors in relation to the transaction, which was premised on a first legal charge, impliedly authorised them to make an initial correction which simply served to identify the signatures and facilitate the charge's registration. The point could be put another way. Authority could be gleaned from the mere fact that the appellants had signed the charge. If a person signs their name, it must follow that they intend their identity to be readily apparent from that signature. So any clarification which only serves to give effect to that prior intention must have been made with prior authority. But my lords, again, there is more. Even if you're not persuaded on the implied authority point, the appellants expressly authorised DJM to take a step. Can I take you to page 266 of Bunderley? And this is DJM's standard terms and conditions.
266.
266, my lord. Those standard terms and conditions, which I should say we understand from DJM, I appreciate that's basically I need to put the point, were in effect at the time, stated, we are authorised, unless otherwise agreed, to take such action as we think necessary to obtain the required result. We shall not refer to the client for specific instructions every time we take a step. If there is a limit to what we are required to do, or a limit to expenditure, we must be notified of this in advance. Now, just adopting the language of that provision, the required result, which DJM had been instructed to undertake, to procure rather, included the registration of a legal charge. But again, if that wasn't enough, the alterations were authorised, we say, on a separate basis by the power of attorney within the charge itself. Now, my learned friend has referred to this as a Henry VIII point. I must say I respectfully disagree with that. The charge was already binding and validly executed prior to the alteration. And even if it was yet to be registered with the Land Registry, it still had effect as a deed under which the parties had legal rights and obligations. And just as a logical point, it could only have been invalidated from the time that the alterations were made. There is no authority, and I don't think my learned friend has sought to put the point precisely in these terms, that Piggott's case operates retrospectively. Well, I'll be corrected if I'm wrong on that. So at the time that this alteration was made, the charge was effective, and that included the power of attorney granted at clause 17. Now, this can be seen at page 298 of Bunderley. Clause 17.1. I won't read it out in full because my learned friend's already taken you through it. But the short point we'd make is this. This power of attorney authorised both SBS and DJM, who were also acting with SBS's authority, to perfect any act which may be required or may be deemed proper for any of the purposes referred to in or otherwise in connection with this charge. Now, the act in question that needed to be perfected was the unsuccessful first attempt to register the charge with the Land Registry. The solicitors tried to register the charge, the Land Registry came back and asked for clarification as to the signature blocks, and in order to perfect that act, this initial correction was necessary. So we say it clearly comes within the scope of that authority. And if it's maintained, as I understand it to be the case, albeit faintly put, that registering the charge might not come within the scope of that authority, you'll recall that the power of attorney is directed towards any of the purposes referred to in or otherwise in connection with this charge. And at clause 26, page 302 of Bundle E, there is a provision which refers to the mortgagor applying to the Chief Land Registrar for a restriction in the following terms. And in the standard wording in italics, it's clear that that provision contemplates that the charge would be referred to in the charges register. So for that obligation to be complied with, the charge would have to be in the charges register. So perfecting the registration of the charge must, we say, be within one of the purposes referred to or otherwise in connection with the charge. My Lords, we would also dispute, although I won't address you on the point in detail, given what we've said about authority, that an alteration of this nature would clear the materiality threshold in Piggott's case. It merely served to correct the signature blocks rather than amend any of the substantive provisions within the legal charge. It's very far removed from a case like, for example, the Bolt decision heard by Mr. Justice Michael Green, which is referred to in my learned friend's skeleton argument, where effectively a new property was added to the scope of the charge. And on any view, and I won't develop this point unless you particularly benefit from hearing about it, injunctive relief would be OTOs, given that really taking the appellant's case at its highest on the alterations, the charge would simply have effect as an equitable charge. You've already heard about clause 19 in the document at page 214 of Bundle B. I won't take you through it. But from a practical perspective, even if there was a seriously arguable basis for impugning the charge as a legal charge, there would still be a very clear route to an order for sale on the basis of an equitable charge. And in our submission, that factor, however unusual, should also militate against the granting of an injunction today. So, my Lords, unless I can be of any further assistance, that concludes my submissions.
No, thank you very much, Mr. Grayson.
Mr. Stratton. No more than 2 minutes in reply, I promise. There's only 3 new points that I want to address. The first one is the suggestion that this injunction should have been issued in the 4th claim rather than here. And there was a suggestion that it was issued here to subvert the requirements of the civil restraint order. I just want to say that that is not true. Without waiver, you can see that that application was made the day after I was instructed. And the reason for it was that practically we thought it could be determined today and that we would have difficulty getting a listing in the High Court to determine it. Practically, it really is now or never in relation to the injunction, while reserving our rights in that respect. The second new point was my learned friend said that Mr. and Mrs. Evans should have raised these issues about the sale earlier or in their application notice and provided evidence of it. But my Lords, we only found out that there was this proposed sale on foot yesterday afternoon after the application notice was put in. Of course, I'd like to give you valuation evidence, but at this stage, in this limited time, I can only point to, number one, the stark disparity between those two figures, 1.2 million and 900,000, and number two, the embarrassingly perfunctory way in which this sale process has been undertaken. Third point, in relation to impecuniosity. I explained that while the appellants are on universal credit, we think there is some value in the house itself. In particular, the difference between the 1.2 million in the house, that we say the house is worth, and the £1 million the Building Society are claiming against it. I should also say, we don't accept that £1 million figure. And the most compelling reason for that is that the appropriate time Mr. and Mrs. Evans intend to argue that the indemnity is not enforceable. This heads-I-win, tails-you-lose provision that allows them to recover costs on an indemnity basis, even if the Building Society makes claims that are ultimately found not just to fail, but to be hopeless. we say that's unenforceable as an unfair term, and that would knock 230,000 also off the amount that's claimed. At the end of this hearing, my lords, I haven't been able to do justice in full to Mr. and Mrs. Evans' case in light of the limited time available, but I submit we have met the low standard of a serious issue to be tried. And so for those reasons, we'd ask you to hold the ring with the injunction until these arguable points can be heard and determined for the first time. My lords, I might just take one final moment to confer. My lords, apologies for that. Just two other very small points to raise. Mr. and Mrs. Evans have pointed out to me that there's already proceedings on foot to chip away at the amount of costs claimed and seek assessment of them. And second, Mr. and Mrs. Evans have told me that they instructed DJM not to alter the charge without their consent. My lords, is there any further way in which I can assist you at this stage?
No, thank you very much indeed. We're going to rise for a few minutes just to consider where we've got to, and we'll come back in a few minutes and tell you where that is.
Thank you, my lord.
What rise in favour?
Was to be deferral of your reconsideration. I'll just take it that way. If there was to be a deferral of your reconsideration, I think they might have given us a bit of an indication about their view about remitting it to, about having it dealt with in London, because if the Cardiff strikeouts in Cardiff and the wheels are already turning there, wasn't there a listing on Tuesday? So that's why, practically speaking, we're happy to just have it tied to the oral reconsideration, and it might be tied to the Cardiff strike, and it might be fruitless to try and hold it out by reference to an application that might have brought. So yeah, I mean, maybe take instructions on those points.
Court rise in favour.
Thank you very much to both counsel. Particular thanks to Mr. Stratton for bringing this up at such a late stage and presenting the case so ably on behalf of the appellants. Notwithstanding that, we reached the following decisions, and we will give reasons in due course after this. First of all, we will grant allow the appeal on the narrow ground that's been discussed already. Secondly, we will constitute ourselves as the High Court and exercise the question of reconsideration ourselves, and we will refuse permission to appeal on that reconsideration. We will also refuse the ancillary applications which follow on from that to deduce new evidence within that. And thirdly, we're going to refuse the injunction. We will, as I say, provide full reasons in due course. As far as those reasons are concerned, we'll distribute them in the usual way for corrections. You will all know that when they're sent out in that way, they are confidential. We ask for typographical corrections only. They mustn't be disseminated any further than the list of people that's provided to us. And we would expect an order to be agreed between the parties insofar as possible. If not, we'll take submissions in writing and deal with everything in writing thereafter. Again, thank you very much.
Court rise in favour.